Morning up.
Yes, please. Chief Judge, Your Honors, and may it please the court, Sanford Kenny with Weber Crapping Lien on behalf of Appellants the Simmons. At this time, I would like to reserve 5 minutes for a moment. It is well established that if venue is proper in more than one place, the plaintiffs have the privilege of selecting which venue is most favorable, and that selection will not be disturbed absent evidence of substantial inconvenience or undue expense to the witnesses or the parties.
Let me ask you, I want to make sure it's clear, were your clients conceding or admitting that they would be willing to travel to Tampa for discovery purposes?
Absolutely, Your Honor. They've consented to the fact that they would be subject to Hillsborough County's jurisdiction by filing there, that Rule 1.310 would require them to be deposed there, and it's only 40 miles. It's about a 50-minute drive. I just checked this morning. I mean, it's not really all that far or inconvenience. It's close. I drove about that to get here this morning from Pinellas County. And they have the right to choose which venue, regardless of the reasons. The reasons are irrelevant. They have the privilege of selecting that forum, and without Heritage being able to prove that they as a party or some of their witnesses would be substantially inconvenienced, it's not sufficient to be able to transfer. And that's why
you would agree there's no dispute about their allegations as connections.
absolutely not, but we agree that
so the argument is extent of their evidence inconvenience to Heritage. Did Heritage present any evidence of inconvenience?
No, the Heritage provided no affidavits, no sworn testimony, no record evidence of any kind, because there was no record evidence of any kind.
So I understand that the presumption, that where the defendant resides, and that the movement has the burden proved by evidence. Correct.
Correct.
But at the hearing, you didn't object to any of their representation. We don't know that attorneys' representations are not evidence, but you didn't object to that. I think that's what your opponent's saying. You have waived that. But are you arguing that despite that, they still have to produce evidence, not attorney argument?
Our argument is essentially twofold, as Your Honor mentioned. Yes, we disagree that it was waived, although it might be close. But even if the court deems it waived, it was still an abuse of discretion, because the facts, even if accepted as true, do not amount to substantial inconvenience that warrant a transfer of venue under forum nonconvenience. They have shown through any evidence at all, the facts that they do present, as Judge LaRose pointed out, is merely the fact that the property is located in Polk County, the inspections would occur there, but they don't ever name any specific witnesses other than the plaintiffs themselves who would be inconvenienced by coming to Hillsborough County. They don't.
By the time this lawsuit comes around, does the record indicate the extent of any inspections that have been done? Have repairs been done?
The only facts in the record are what were in the complaint. I believe one inspection had occurred at the time that the motion to dismiss or the alternative to motion to transfer was filed. But the record's small, because essentially nothing has happened in this case so far, other than the complaint being filed and the case being transferred to Polk County.
Well, I guess your opponent will try to convince me, but your clients live in Polk County.
Correct.
And nobody disputes that. But
I don't believe so.
What evidence have they shown that they are based in Tampa, that they will be inconvenienced that litigation?
They have shown absolutely no inconvenience. That is the crux of this appeal, is the fact that even accepting all of the evidence that they did present, if you could call it that, the facts contained within the complaint, which we all can see, is located there, they live there, they chose to file in Hillsborough County because venue was proper under Rule 47 Section 47.051. I believe in the answer brief, they don't even contest that venue is proper in Hillsborough County. They just simply say it is more convenient because the property is located there and the plaintiffs are located there. But that is not a sufficient reason. That's this court noted in Pocock versus Pocock. simply being a more convenient form is not the basis of a transfer. It's legally erroneous. If it's just more convenient, it has to be substantially inconvenient for a witness or a party. Heritage has only named one witness who would be inconvenienced, and that's the plaintiffs who filed suit in Hillsborough County. That cannot be a sufficient basis to transfer based on forum nonconvenience when they haven't even said that they themselves or any witnesses that they would put on, any defense witnesses, would be inconvenienced.
That's the key here. As we know the case law, whoever files the lawsuit, they get to choose if it's appropriate, whatever venue is. And if one side is want to change for whatever reason, for non-convenient, then at that point, as I understand the case law, the burden then is on them to try to show why it's inconvenient. And based on this record, as I review it, it appears that the party just relied on the allegations in the complaint.
Correct.
There was no affidavit filed. There was nothing presented to the court saying this will be inconvenient because, number one, the property is located in Polk County. We'll have to drive all the way there to do whatever inspection, to do just anything to show that. And what the court basically relied on is I review this record. As a, it said that your clients in Polk County, everything is in Polk County. Whatever needs to be done, everything appears that Polk County may be the better venue, but there's legal justification for it to be in Hillsborough. And this is where we're dealing with right now, is that what evidence on this record to show that Heritage did bring any evidence to show that they are being inconvenient. Am I reading this correctly?
I could not have said it any better myself. There has been no discovery that has taken place. There's no additional facts other than those contained within the complaint. Obviously, we accept that everything within our complaint is taken as true, and the trial court was required to take everything as true. But even that standing alone, there was no actual sworn evidence or affidavits or any explanation at all how this is substantially inconvenient to Heritage. It really comes down to, it's essentially just mere recitation and regurgitations of the facts contained within our complaint below. And then saying, yes, maybe Polk County was a better form because everything is located there, but it is not deprived, and Heritage cannot usurp the Simmons choice of form being properly in Hillsborough County.
And all of us have been to court, and all of us in hindsight have made mistakes. But we're looking at the law where motion by the defendant to dismiss or transfer on the ground of improper venue raises issue of facts which must be resolved by an evidentiary hearing, unless complaint shows on its face that venue is improper. So they're arguing convenience, an attorney's representation, no affidavits, anything. You don't object, or one of your co-counsels don't object, and force them to establish their verdict. And so we have a judge listening to both counsels without any objections, thinking that you all agree that the attorney's arguments are going to be appropriate and enough. And then she makes the decision, and we're looking at it by abuse of discretion. So are you saying we need to reverse and remand for an evidentiary hearing, or what?
I don't believe that an evidentiary hearing was ever actually held, so it could be reversed and remanded specifically to require Heritage to support the arguments with that. But I think even accepting the arguments of counsel, and even if the court deems that this was waived and that the sufficiency of the evidence was not objected to, the facts as it's contained within the record are not sufficient for the trial judge to have warranted a transfer to Polk County. And so it wasn't abuse of discretion.
Well, be careful what you wish for. On this record, I see absolutely nothing of substantial inconvenience to Heritage. So if we want to remand for an evidentiary hearing, given the light of the act.
We believe that the court made its decision, and we're just asking for this court to reverse and remand for the case to be put back into Hillsborough County, because there's been nothing else to show that Heritage would be substantially inconvenienced. And I can't think of a scenario that they would be able to present facts that show that Heritage or its witnesses could be substantially inconvenienced. Like, we're talking, they're abutting counties. It's 40 miles. It's about an hour drive. It strains credulity. It is on I-4, you're right, Judge Flores, but it's difficult to imagine a scenario that if this is sufficient for a forum inconvenience, then what isn't potentially an inconvenient forum? If we're suing an insurance company that's based about 6 miles from this building, it doesn't make any sense that Polk County is more convenient for them. They're relying and sort of juxtaposing our facts to put it back on us, saying, well, you're inconvenienced by being in Hillsborough County, so why don't we take it back to Polk County? That is absolutely backwards from what the actual test is. We don't have to show that it's more convenient to be in Polk County. They have to prove by sworn and competent substantial evidence that they would be substantially burdened or inconvenienced to go to Polk County, and that's just simply not true. And so, to Chief Judge Sleet's point, accepting the facts is true, and even though we didn't maybe properly object at trial, and if the court deems that issue to be waived, the trial court, there was not sufficient facts on this record or any evidence to support that decision.
Would it be appropriate for the trial court to extrapolate based on the complaints? The complaints, everything points to Polk County. Everything. And can you just give deference to the trial court saying, the trial court said, well, obviously, goodness, all the clients are there, the incident is there, everything is there. It seems more convenient based. Can you give that evidence?
I don't believe you can, Your Honor, specifically because the case law does clearly require that the movement's burden is to provide affidavits or sworn testimony, something that is sufficient to show what the burden would be. And although there is the narrow exception that the case law goes into, that if the facts of the complaint alone show the inconvenience, then yes, that maybe could be true, but the facts on this complaint are not sufficient for the trial court to have determined that they would be substantially inconvenienced or that the witnesses or parties would have undue expense by being in Hillsborough County compared to Polk County. So there's really no justification for the trial court having transferred this to Polk County. And with that, I will cede the rest of my time for
Good morning.
Good morning. May it please the court, Angela Flowers of Kabiki Draper on behalf of Heritage Property and Casualty Insurance Company.
Ms. Flowers,
Yes, sir.
what lane my skepticism?
Yes, Your Honor. I've noted a couple of points that came up during your interaction with plaintiff's counsel. And I'll touch on a couple of them, hopefully in an order that's acceptable. One of your first questions had to do with whether or not plaintiffs consented to the lawsuit being filed in Hillsborough County.
Did they consent to discovery?
Either one.
No, my question was more precise.
And I'll broaden it to also encompass even the filing of the lawsuit, because the point is that although we have certain facts in this case which are established and which are uncontradicted, once defendant accomplished meeting their burden of establishing why this was a more convenient forum to be moved to Polk County, the burden shifted to plaintiffs.
Let's take this step one. Plaintiff sued you in your county of residence, correct? That's
Yes.
undisputed.
Yes,
All right, that is a plea.
yes,
You filed a motion to dismiss. You did not attach any evidence whatsoever to support your burden of proving that it's inconvenient, did you?
so I will,
Yes or no?
yes, we
What
did
evidence?
not file any,
Besides what you said below, which is not evidence.
Mhm.
What evidence supported your motion? Change the
right, so the case law that plaintiff themselves have cited in the briefs and
So I'd
discussed
like to know
today.
what you filed. Did you file an affidavit of the adjuster? Did you file an affidavit of the inspector? Did you file an affidavit of the roofing contractor? Did you file an affidavit of anybody saying, all of this occurred in Polk County? This can be really inconvenient from all my people that are gonna repair this house to go to Hillsborough to do anything, much less litigate this.
We did not, because it's not necessary, as the
Says
case,
Which case?
the case law, as I said, cited in the Plaintiff's briefs, as well as referenced here, oral argument, At Home Auto Glass LLC versus Mendota Insurance Company out of the 5th DCA, 345 Southern 3rd, 392, which cites within it the Hall case from the 5th DCA and another line of cases, all of which hold there's an exception that there is no requirement to present evidentiary material when from the face of the complaint, the court can determine the facts necessary to warrant a
All
transfer.
you've shown,
Mhm.
what I read from the complaint
Mhm.
is that there are some connections in Colby County. Your client show substantial burden to go there. So where are all the documents? Does the record demonstrate where all the documents are?
The burden is,
Does the record reflect where the documents are located as it relates to this claim?
what the record reflects, based on the complaint itself, is that the part of this case has to do with real property located in Polk
So we
County,
don't know where the documents.
as in the insurance contract, we do. The contract reflects that the document was delivered to plaintiffs in Polk County, which means that this cause of action arose in Polk
When we
County.
do discover
Mhm.
and we're looking for documents, there's nothing in the record that tells me there's a warehouse in Polk County, warehouse in Tampa that has the documents.
The record also reflects that inspections were conducted at this property in Polk County, and that any future inspections will be conducted in Polk County at this
There's
property.
no evidence by affidavit as to how your contractors, experts, or employees were substantially impacted by having to go to Polk County.
There's no affidavit.
Am I not?
There's no affidavit as to that, but that's
There's
just,
nothing in the complaint other than an inspection was done there.
and that the key witnesses, the insureds, reside in Polk County.
But that's not their burden, it's your burden to show your employees are doing substantially impact.
Well, the case law and the statute sets forth 3 elements which go into consideration of forum nonconvenience. And it doesn't indicate that it is only the defendants themselves as parties or the key witnesses that have to be inconvenienced. It's a global examination because it also folds into the 3rd element, which is in the interest of justice. So when the trial court's considering where the parties are, where the key witnesses are, what all the factors are in terms
But
of,
we don't know any of that, that's my point, we don't know any of that.
well, we know exactly who
We
the
know
parties
this
are.
isn't-
We know,
They live there.
Mhm.
We know an inspection was done there.
correct. So the key
Okay, it's
witnesses,
a connection, but I'm still having trouble understanding your client's substantial inconvenience to basically go 40 miles to Polk County when they could go to the Hillsborough courthouse, which is probably 10, 15 minutes away from their office.
well, substantial inconvenience, this is a weighing process. And it's not anything more than shifting of the scales. And so the court takes these 3 factors. We have the 7 elements which you recognize are reflected on the face of the complaint. And on the other side of the scale, we have one attenuated connection, which is that the defendant has a corporate office in Tampa. Then we have also the interest of justice, where the court weighs the convenience of the court along with the relative convenience or the relative considerations of the public and private justice issues. And of course, folded into this is a concern and also the court being aware of forum shopping. And when you have the scales here and everything is on the side except for one attenuated fact, which is that the defendant has a corporate office in Tampa, there's not a sufficient ability to say that the trial judge abused its discretion in going with the greater weight of the evidence, which shows that Polk County is the more convenient forum. And this reference, to that it has to be anything more than that, citing to the Pocock case, which is a case in which there was a forum selection clause in that contract. And the court there stated that it was a higher standard for the trial court to undo a forum selection clause. We don't have a contractual forum selection provision here. We're dealing with a standard of more convenient. And the factors of the statute, we know that the parties are split. One's in Polk County and one is in Tampa. And then we know that the key witnesses, there would be other witnesses, but we know the key witnesses, the before and after witnesses, the witnesses who lived at this property and are going to testify as to its condition.
We don't know about your witnesses.
We don't. So we're going to go with what we know about. We know about the key witnesses, and we know that they are located in Polk County. Plaintiffs had the burden to do more than just present attorney argument that their plaintiffs or that their client plaintiffs were willing to come to Hillsborough County, or that they had even wanted this file.
Excuse me just a second. I gotta stop you. Single case puts the burden on the movement. They filed suit saying that you had principal place of business in Hillsborough County, and you admit that. That is enough for a presumption. Every case, even the case you just cited in front of us today, says you need to have evidence. It's your burden. Affidavits and evidence. Help me out, man.
Well, I do disagree, because in footnote 3 of the case I cited to you, the words are that the exception is that when the face of the complaint indicates that the forum selection is inappropriate because the more convenient location is the one to which the trial judge would transfer.
The complaint simply says the house is in Polk County, period. You're reading.
Actually, the face of the complaint says many more things than that. It does indicate that the location of the property is in Polk County. It indicates that the damage, the causation for any injury to the property occurred in Polk County when Hurricane Ian impacted Polk County. The complaint goes on to say that the cause of action accrued in Polk County. The complaint goes on to say that this is.
I've read that, but the case law says you, as the movement, must file evidence. All you had to do was file the affidavit of the adjuster to say exactly what you were saying, because what you said to Judge Polo is not evidence.
Well, I will respectfully disagree, and I'll leave the auto case to say, the auto glass case to say what it says. And I will then also want to point out to the court that plaintiff never raised this objection below. And I believe because they were aware of the auto glass exception. No, they did. They must raise an objection. They consented.
You're citing all kinds of cases that do not support. You give me a case where the plaintiff has to require the defendant at a hearing to produce the evidence and make an argument.
Well, the plaintiff must object
No,
rather than
okay.
consent to proceed.
Give me the case, please. I'm looking.
Well, it's a basic, I would cite any of the basic
No, I
preservation
do
there.
want to answer. I'm not getting it.
Well, what I'm trying to stand by is my position that the case law does say that an exception to the need to present either affidavits or deposition or any other type of trial type evidence. The exception is when from the face of the complaint, the trial court can discern that the more convenient forum is the forum to which the transfer is made.
Yeah, but without evidence, we can't assume that everybody that worked on this house is from Polk County. You could have hired them from an insurance company who's got a cadre of experts all the time, all on retention. You could have come from Hillsborough and gone over there. We don't know because we don't have any evidence.
Ultimately, assuredly, the trial court is taking notice of certain well-known facts in terms of how a property insurance case involving a question of scope and price works, and that the heart of this case is located in Polk County, as well as the key witnesses.
If I may, Ms. Flowers, before your time is up, and one of the things that I'm struggling with, and I will give you the opportunity. There's the tobacco cases, and I actually have it highlighted, that it dealt with issue of form non-convenient. Here's what the court said here. The defendant did not identify specific witnesses who would be substantially inconvenienced by having the case proceed in Miami-Dade, or provide any evidence that any evidence would impose a change of venue. In the absence of supporting evidence presented, it was fair for the trial court to order the transfer. And I think that's where it's starting. Your argument is very good. It easily, these allegations. But what I'm struggling, is it follows what just three and just follows is that. We don't know that, we don't know, and the burden this. Is. In the issue. Indicate. It's what is. So that's what.
Well, I think that not every case is focused on the witness aspect of 47.122. There are three different factors, and as the statute reads, it's parties or witnesses or interests of justice. So if the case is based solely on who the witnesses are and where they're coming from, that becomes the focus of how to make the decision. But here, Heritage was addressing each of those three factors, where the parties are located, and the parties, the plaintiffs, it's a stronger connection to Polk County because that's where the property is versus the attenuated connection of where a defendant has a corporate office. Then in terms of focusing on witnesses, what we can extract from the complaint is that the key witnesses, those who were at the residence, who own this property that's claimed to be damaged, they are located in Polk County. And we did not go a step further to address any other witnesses. We just addressed those key witnesses. And then in terms of the interests of justice, you have the issues about the fact that the heart of this matter is real property located in Polk County. That's an interest of justice issue, as well as the fact of how the court might conduct an insurance price and scope property trial, whether or not a jury review might or might not be warranted. We don't know, but the court can take into consideration all the interests of justice, which go into the court's convenience, as well as to, the relative issues of private and public interest in justice. And there is no interest in forum shopping and removing a case to a county that has minimal, almost no interest in being brought in this community. And then we have a set of facts that plaintiff agreed and consented to the trial judge making a determination on the facts that are in this record. Plaintiff was willing to go forward. It's been after the fact. It's only on appeal that plaintiff has suggested that there was insufficient evidence. It's only been on appeal that plaintiff raised the issue of whether or not there should have been any affidavits. So plaintiff consented to the trial judge making the determination on this record. And so in light of that, the plaintiff has not carried their burden of showing that the trial judge abused her discretion in transferring this case to Polk County. On those grounds, Your Honor, unless there are any further questions, we would ask that this court affirm the trial court's decision to place this litigation in Polk County, where the heart of the matter exists. Thank you.
Thank you.
Chief Judge Rowlands will please the court. Just a couple of quick points. My esteemed colleague on the other side keeps referring to just the mere showing that another form is more convenient. The case law is clear. It must show a substantial burden. The mere fact that another form is convenient is simply insufficient. And as Chief Judge Sleet and Judge LaRose both commented, there simply has been no evidence presented to the trial court. And even if this court accepts that there was a waiver, if the case law is clear that the judge must consider sworn affidavits or other record evidence, we don't know absolutely nothing about their witnesses. They could be from anywhere, and they've never met their burden by providing any of that evidence, and the burden never shifted to the plaintiffs to prove their case for them. As it relates to the inspections of the property, this goes back to the fact that even accepting all of the facts as true in the complaint, they're nothing more than a recitation and regurgitation of the facts in the complaint that show a lot of stuff is in Polk County. It has no explanation as to the burden imposed on Heritage, much less a substantial burden on Heritage or any of its witnesses. As it relates to the fact that the plaintiffs are the key witnesses, they're also the party who has the privilege of selecting their forum. It's uncontested that Hillsborough County is a proper forum for this case to have been brought in, and to try to flip the fact that the plaintiffs are somehow the party that's inconvenienced by their own forum selection, it simply defies reason. The record was insufficient for the trial court to have made a determination that Heritage would be substantially burdened. And they have failed to demonstrate that there's any compelling reason to override the CEMEC's chosen forum, and the trial court abused its discretion by granting the motion to transfer without any record evidence to support or justify that decision, and this court should reverse. Thank you.
Thank you, Mike. Last case, Citrus Park Mall, Cinnamon Hall property, which is master collision repair, Inc.